My name is Kiowa Hammonds, and I'm here for Copy Bytes Part 2. This is Part 2 in a two-part series. My day job is I'm the manager of rights clearance at the New York Public Library. Just to give a bit of background, my duties there include researching rights holders within New York Public Library's collections. I also manage a team of digitization coordinators who are focused on project management for digitization of collection materials, including copyright research and active clearance. We are also responsible for rights metadata implementation, which documents our rights research, the permissions, and required copyright notices. I also advise staff on copyright-related questions and policies, draft and review contracts and licenses related to copyright, and rights-related issues for exhibitions and publications, among other duties. So before we get started, I need to say that nothing you hear today should be construed as legal advice. This information is given for legal education only. It may not work for your specific situation, and if you need legal advice for your particular situation, I suggest you engage with legal counsel. Nothing myself, as the presenter says today, should be attributed to a particular client. All right, with that, let's get into it. So I wanted to start briefly by recapping what we were doing in part 1 to kind of go into part 2. So in part 1, we discussed briefly about what digitization is and what it means for libraries, specifically its history, the positive and negatives of collection digitization for libraries. And we also discussed how U.S. copyright law helps and restricts digitization projects, including exceptions for libraries under Section 108 of U.S. copyright law and fair use. We also looked at how to determine if a work has copyright protections or is in the public domain, and how institutions can seek out permission for digitization through licensing or through transfer of copyright from a rights holder. And we concluded with a look at some ways libraries can exercise best practices for digitization by considering some of the following: why digitization is important for your institution, proper analysis of the materials for digitization, suggestions about adopting open access policies for your collections, an implementation of a copyright management information system, or CMI, how to participate with educational initiatives, and the need for collaboration and partnerships. So today we'll be talking again about digitization and copyright, but more specifically, how digital access strategies such as e-resources, web archives, and controlled digital lending affect libraries, how libraries can navigate collection strategies in the new normal of born digital archives and audio and moving image materials, and the idea of a global digital archive. So again, just to recap, the types of digitization that we've been focusing on is collection digitization, which is primarily special collections, including manuscripts and archives, ebooks, e-articles, and e-journals, massive open online courses, or MOOCs, audio and moving image materials, and born digital materials. Now, in part 1, we really focused on collection digitization specifically, books, manuscripts, archives. But here we're going to start with learning a bit more about the E's of the e-resources. So let's get started. Now, there are many databases that already include digitized content, specifically for indexed collections of magazines, journals, newspaper articles, abstracts, and other information. There are several advantages for subscribing to library databases. They serve as aggregates for large runs of different periodicals, articles, books, etc. There's standardization of the scans that are checked for accuracy by publishers and then licensed for distribution in an electronic form. This is important when comparing information searches to internet search engines, which give a deluge of different sources that are filtered just as much by ad revenue as for accuracy. Many databases also include optical character recognition, or OCR, and other search functionality that can offer a great advantage for our researchers to navigate through. And these databases should also be clearing copyrighted material. So when subscribing to one under a license, there is the assurance that your institution is not violating another's copyright. And if your library has particular runs of periodicals, out-of-print books, or special collections, Your institution may also be approached by an e-resource company to have materials digitized for their database. There are certainly advantages for partnering with an e-resource company for digitization, particularly when considering digitization costs. There's also the advantage of exposure for your collections and broader access to patrons outside of your immediate demographic. You may also be able to negotiate free or discounted subscriptions to a database in exchange for lending your collection materials for the digitization project. And if your institution has a means of retaining those files, you could consider negotiating to receive copies of the digitized files for your own collection. You want to keep in mind that under Section 108 exceptions, libraries do have some leverage to retain these files for preservation purposes or even service them on site. And if the materials are in the public domain, it's even better. But it's important to mention that these databases come at a literal price, with libraries spending a big chunk of their budgets on licensing. These licenses mean that the institution does not own the materials and are subject to the limitations and restrictions dictated by private companies, including restrictions on copying. In cases of loaning materials to a company for digitization from your own collections and getting perhaps those copies yourself, you want to make sure that you are aware that there may be embargoes or other restrictions on how your institution may use the files, even though the original physical materials are in your collections to begin with. And it's very important to keep in mind that unless an agreement specifically states that the licensee is exempted to these restrictions based on exceptions within copyright law, they will be subject to the restrictions regardless of Section 108, first sale, or fair use. So I can't emphasize enough here the importance of reviewing the licensing agreements for library databases when both subscribing to one or if approached by a company to digitize your own materials in your collection for their use. So from a copyright perspective, it's also essential that if subscribing to a database, that your institution's goals align with the uses and restrictions outlined in that license. If, for instance, there are caps on the amount of users that may access the database, you want to make sure that this fits into the number of your projected users. If there are limits to copying, you want to make sure that this won't hinder the uses of your patrons, particularly in the new normal of remote access. And you definitely want to make sure that your institution is not responsible for indemnifying the database for any potential infringement of copyright. You may also be able to negotiate a warranty in your license that all permissions have been cleared by this company. If a warranty or indemnification can't be negotiated in your license, make sure that your institution is aware of the risk that may be involved in licensing from a database. You want to make sure that the access to the digital assets outweighs the potential risk. So a helpful tip here is for assessing risk is researching the database itself. If you're negotiating with a large company with many library subscribers, then there is some security that the company would be taking the necessary precautions of clearing the material for inclusion in their database. Remember that for the most part, you will be dealing with a for-profit company that are trying to make money off the licensing of their databases, and therefore they should be spending the time and the money to clear in copyright materials from and using them properly in their own digital collections. Now, an alternative to paid library databases are open educational resources, or what we'll call OER. The Organization for Economic Cooperation and Development defines OER as digitized materials offered freely and openly for educators, students, and self-learners to use and reuse for teaching, learning, and research. OER includes learning content, software tools to develop, use, and distribute that content, and implementation resources such as open licenses. OER databases are able to do this by including content that is either in the public domain or that have been released under an open license that permits a no-cost access, use, adaptation, and redistribution by others with few, if any, restrictions. These licenses include Creative Commons licenses, which normally require attribution to the author, and restrictions related to reuse or commercial redistribution. Now, there are many types of OER resources for users. These include course materials, modules, learning objects, textbooks, videos, tests, software, and other tools. There are also lesson plans called Massive Open Online Courses, or MOOCs. MOOCs are free online courses that are available to anyone who wants to enroll. They are user-generated and in a wide variety of subjects. Now, although OER has a very broad definition that encompasses almost any free educational tool, it's important that the scope is primarily defined by copyright. For example, OER videos should not be made available on many popular streaming services like YouTube or Spotify, since these services include additional terms and conditions that may be more limiting than the content itself. Some examples of OER databases include the free Libre open software, source software, or FLOSS, weird acronym there, MIT's OpenCourseWare, and Connections. Now, OER resources do have many advantages, including easy access for students through the internet, the openness to tailor the materials to specific lesson plans, and of course, cost. But there are some disadvantages to consider as well. For one, since much of the material may be openly edited and not peer-reviewed, there is a question of the quality of materials available. Also, the fact that these resources are online may mean that they are less accessible to some users. And the fact that although these materials are presumably in the public domain or properly licensed, there is always the risk with an open content management system that some materials may have copyright issues that were not addressed. Also, some examples of this being that copyright protections may be from other countries. Pre-existing licenses may be out there for their original sources, and there may be trademark or right of publicity issues in the materials. But even with these disadvantages in mind, the fact that OER is recognized as a valuable resource internationally and is openly embraced by so many academic institutions, that means that these databases can grow and evolve, serving as a much-needed alternative to licensing databases. So like articles and databases, ebook lending represents a growing portion of the types of materials we are offering patrons within the digital age. Ebooks are available to libraries for lending through a few different ways: by subscription, purchase, and patron on-demand service accounts. Now, ebooks have become an essential medium for lending materials for libraries. But it's important to keep in mind that ebook licenses are generally more expensive than buying physical copies in bulk from publishers. And since they are licensed, there are added restrictions not found in physical copying or lending under the first sale doctrine in Section 108. So because libraries are licensing these materials, they are under the limitations outlined in their agreements with those publishers and beholden to the pricing and number of digital copies that can be lent. Another digitization effort is web archiving, whereby an institution collects portions of the World Wide Web as a means of information preservation. Information, images, tweets, these can all be deleted from the internet and rendered unsearchable, but web archiving is a means to preserve this important content. The Financial Industry Regulatory Authority, or FINRA, another weird acronym for you. For example, that FINRA has implemented in its rules and guidelines that they require businesses now to web archive to ensure that there's company transparency for its members. The Internet Archive's Wayback Machine is probably the best example, but we should not discount the many library and cultural institutions that also participate in this form of digital archiving and preservation. These include the Library of Congress, National Archives of the UK, Stanford University, and many of the institutions that use the Archivit platform for storage. Now, there are three main methods of web archiving. The first is remote harvesting. This is probably the most common method and utilizes automated bots called web crawlers to collect web pages in a similar way that we browse the internet. There's also, the Wayback Machine is probably the best example of use of remote harvesting. And it's important to note that although a harvested website may be an exact replica of the original, does not mean that the hyperlinks embedded in a website are still functional if those sites have been disabled. The second method is database archiving. This method refers to the harvesting of the information from a website, but applying it to a standard schema such as XML, whereby the contents may be further exported or retained. So this method means that the logic and ordering of the original site is not retained, but the information that's on there is extracted and remains an important informational tool. And the third is transactional archiving. This collects transactions between a web server and a web browser. So this means that the user interactions with a particular website or page is retained, including the access date and time. This is particularly valuable for verifying what content was publicly available at a given time. Now, although the World Wide Web is a publicly accessible tool of information, it doesn't necessarily mean that there are no copyright concerns with the retaining of this information. As the writer and librarian Peter Lyman puts it, although the web is popularly regarded as a public domain resource, it is copyrighted. Thus, archivists have no legal right to copy the web. Let's explore that a little bit. So private not-for-profits like WebSite and the Internet Archive or the Internet Memory Foundation have circumvented the copyright issues by allowing content owners to either hide web pages or have their sites removed upon request, while other archives have limited access to within their own buildings. Also, we need to keep in mind the Authors Guild versus Google and HathiTrust cases, which set some precedent in favor of web archiving. As we talked about in part one, the courts found that Google and HathiTrust's use of data mining of in-copyright works was indeed transformative through its use of the information through Google's search engine and the limited distribution of the copied book scans. So although in the case of web archiving, the full in-copyright content may be made available, it is more for the purpose of information retention than a commercial use or limited access point for this information. So I would say that if a case were to arise against an institution practicing web archiving, the transformative nature of the archive site as a means of preservation would hopefully stand the argument of copyright infringement. So another important method of access for digital information that is being utilized more and more is controlled digital lending, and this is specific to libraries. This is a bit of a long quote, but bear with me. As defined in the position statement on controlled digital lending, properly implemented CDL enables a library to circulate a digitized title in place of a physical one in a controlled manner. Under this approach, a library may only loan simultaneously the number of copies that it has legitimately acquired, usually through purchase or donation. So for example, if a library owns 3 copies of a title and digitizes 1 copy, it may use CDL to circulate that 1 digitized copy and the 2 print copies, or 3 digital copies, or 2 digital copies and 1 print. So in all these cases, it could only circulate the same number of copies that it owned before digitization. Essentially, CDL must maintain an own-to-loan ratio. Circulation in any format is controlled so that only one user can use a given copy at a time for a limited time. So basically, this one-to-one lending of a book means that a patron has the option to check out either the physical copy or the digital scan, but once one format has been loaned, the other will remain inaccessible until the item is returned. The practice of controlled digital lending should follow 3 principles. A library must own a legal copy of the physical book by purchase or gift. The library must maintain an own-to-loan ratio, simultaneously lending no more copies than it legally owns, and the library must use technical measures to ensure that the digital file cannot be copied or redistributed. So the legal framework behind CDL encompasses provisions allotted in Section 109, which is the first sale doctrine, fair use under Section 107, and Section 108 exceptions for libraries. So let's take a second and go through those in a little bit more detail. So Section 109, the first sale doctrine, allows purchasers of physical copies of items to do what they wish with their copy, without the prospect of a copyright holder controlling downstream use of that copy. This is what allows us to buy a book and resell it, or for libraries to purchase books and then lend them to our patrons. CDL utilizes this protection by arguing that as an owner of a book, a library is allowed to lend either a physical copy or a digital surrogate to our patrons, as long as only the physical or digital copy is lent to a single patron at a time. It's important here to note that the language of Section 109 refers to the particular copy owned by an individual or institution, and the courts, though, have struggled with how a digital copy fits into this logic of a particular copy or a particular instance. To further the rationale of CDL, a library must also utilize additional exceptions for libraries under Section 108. As we talked about it a bit in Part 1, Section 108 allows libraries to make preservation copies, which is interpreted as helping the argument for libraries to make digital copies of collection items. 108 does not limit what libraries can do with these copies and acts as a complement to other provisions such as fair use. Circling back to the Authors Guild versus HathiTrust case, the courts held that Section 108 does not foreclose application of fair use to library uses. So the connecting tissue here between making a digital copy of a physical item owned by a library and servicing that copy to the public is fair use. Applying the 4 factors of fair use, we can see an argument for how CDL may fall into this exception. In principle, CDL holds to the idea that libraries can broaden their traditional lending role to the digital environment. So in considering the 4 factors of fair use, under the purpose and character of the use, arguably the idea of CDL is to broaden libraries' traditional lending role to the digital environment. The courts had previously stated in Campbell v. Acuff Rose Music, the Roy Orbison Estate versus Two Live Crew case, that fair use is transformative if it adds something new with a further purpose or a different character, altering the first with new expression, meaning, or message. And as we saw in the Authors Guild case against Google and HathiTrust, the court cited that digitization can be transformative, contingent upon how the files or data is actually used. Under Factor 2, the nature of the copyrighted work, this factor doesn't play a significant role in the proponents of CDL's assessment and argument, but a way a library could incorporate this factor would be to focus on releasing only out-of-print or commercially unavailable works, such as orphan works or works of scholarly or scientific nature. Factor 3, the amount and substantiality of the portion used. Now, it's no secret that for CDL to work, the entire book must be scanned and made available. However, returning to the HathiTrust and Google cases, the courts determined that the transformative use of the digital scans can mean that an entire scan must be made in order for it to be transformative. And Factor 4, the effect of the use on the potential market for the value of the original work, libraries being open to the public and the limitations of access of one-to-one lending means that the amount of loss from the potential market is arguably negligible. But we need to bear in mind that controlled digital lending is not foolproof, and institutions must conduct a thorough risk assessment before embarking on such a large-scale project. For one, there isn't a lot of legal precedents in case law that are directly involving libraries. Also, there is some ambiguity of what a transformative use is when considering controlled digital lending. Although the courts have acknowledged some transformative use through digitization, again, Google Books versus HathiTrust, Google Books and HathiTrust, the courts have largely focused on how those projects enabled transformative access to information by enabling text search, not the ramifications of lending out full scanned items. The exception, though, is probably in the HathiTrust case where the distribution of full text scans for those with print disabilities was seen as the courts as a transformative use. But arguably, the use of transformative when dealing with CDL may be a stretch. And of course, recent cases like Hachette versus Internet Archive certainly doesn't help the defense of CDL. So to give a little bit of background about that case, Hache versus Internet Archive was a recent case held in the U.S. District Court for the Southern District of New York in 2023 and is currently waiting on an appeal. The case concerns Internet Archive's National Emergency Library, which came about during the early part of the COVID-19 lockdown. Previously, Internet Archive serviced scans of books through their open library system, which uses the controlled digital lending model of one-to-one lending, with the physical books available for loan at their center in San Francisco, California. However, because of the limitation of access caused by the international shutdown of public spaces during the early days of the pandemic, in March 2020, Internet Archive opened restrictions on patron access to copies through its emergency library service, allowing multiple loans of the same item to be lent out at once. The lawsuit was filed 2 months later by the publishers, and these publishers included Hachette Book Group, Penguin Random House, HarperCollins, and Wiley. Now, although the case concerned a system that fell outside of CDL's one-to-one lending model, Internet Archive believed that some of the same principles that justified the CDL model also applied here to their emergency library, mainly first sale, Section 108 exceptions for libraries, and fair use. So far, the courts haven't, unfortunately, seen it that way, believing that the emergency library's use of the scans was not transformative and caused direct market harm to the publishers. Now, the final impact of this case will certainly affect how libraries approach controlled digital lending, and regardless of our opinions about Internet Archive's National Emergency Library, I do think it's very, very important that collecting institutions continue to explore the CDL model, particularly in cases of out-of-print works and orphan works. So let's switch gears now and look at born digital materials. The term born digital is simply that, items that are originally created in a digital format. This includes websites, email, digital photographs, electronic records, and software programs. So born digital basically encompasses websites, emails, digital photographs, electronic records, and software programs. If you think of your own personal archives, how much of it exists in an analog physical format? Now, I'm sure there's more than a few letter writers out there in the audience today, but what about your texts, your tweets, your photos, your movies, and other creative output that exists maybe solely on your phone or your tablet? As collecting institutions, we are obligated to continue collecting materials regardless of physical or digital formats. The Barack Obama Presidential Library will be the first of its kind to be fully digital. And basically, because that's for that collection, 95% of it were born digital to begin with. Now, it would be another two-part series at least to speak about the infrastructure and challenges of accessibility of properly storing and maintaining born digital collections. But to speak about copyright, we must keep in mind that copyright protections and exceptions are the same regardless if a work originated in a digital or analog format. This includes exclusive rights that allow a creator protections for their intellectual property, but also exceptions for use under fair use. Also, because of the ease of creating born digital content, we must be careful of attribution from everything from who sent an email to who may have access to a computer to create content. We must also be aware that the global internet means that new works may be created across many different international copyright laws. So we may need to navigate and respect the copyright protections of many different countries. And there are certainly challenges that copyright law creates for libraries collecting born digital materials. For example, Section 108, which offers libraries a means of preservation in analog and digital formats, still limit these to 3 copies, which doesn't help many of the preservation protocols that require more than 3 copies in order for proper redundancy. The Digital Millennium Copyright Act also prohibits circumvention of encryption mechanisms that control access to digital content. So for preservation of software in particular, we may not be able to access an encrypted file unless permission or login information is provided by that copyright holder. Now, fortunately, there have in the last years been attempts at updating library exceptions under 108 and the Digital Millennium Copyright Act to speak more directly to born digital materials, and hopefully we'll see some of these improvements in the near future. So I'd like to end this presentation by talking briefly about the concept of a universal library and how digitization may play a role in that. The concept of a library that has universal holdings dates back to the Library of Alexandria in the 2nd and 3rd centuries BC. And regardless if the Library of Alexandria really existed, it has been an idea that has captivated many in and out of the library field ever since. I, for one, started thinking about librarianship as a career path after reading Jorge Luis Borges's The Library of Babel, which depicted a library holding all knowledge and compared it to an inescapable labyrinth, which is a little weird way to get into libraries, but well, that's how I did it. But could an actual universal library be achieved through digitization? Maybe not in the sense of a repository for all knowledge, but perhaps one that shows a more encompassing breadth of knowledge spanning all cultures. The Library of Congress's World Digital Library, Carnegie Mellon University's Universal Library, DPLA, Project Gutenberg, and the Internet Archive are just some of the digital repositories that are attempting this idea at some scale. And I think at the forefront of these endeavors is our brick and mortar libraries, which collectively house so much of this knowledge. And it's important that when considering copyright law, that we look at it as both a tool that can help bring these visions to fruition, as they can bring them in fruition in an equitable and responsible manner, but also as a challenge that we must continuously be reevaluating and hopefully adapted to speak to the times and needs in the digital world that we live in now. So with that, we conclude part 2 of my discussion on digitization and copyright. I hope it was helpful. So thanks, Metro, and thanks everyone for attending. Really appreciate it.